Inside America's Boardrooms, the informational show for board members and corporate secretaries. Brought to you with Knowledge Partners, NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini Goodrich and Rosati, Donnelly Financial Solutions, and the Society for Corporate Governance.
Welcome to this edition of Inside America's Boardrooms. I'm TK Kerstetter, the CEO of Boardroom Resources and the editor-at-large for Corporate Board Member Magazine. It's my pleasure to welcome you to the show. We're going to be talking today about a roadmap to avoiding director and boardroom liability risks. And joining us, because this obviously has a legal bent, is our legal advisor on the show. Please welcome William Chandler, who's the former Chancellor of the Delaware Court of Chancery and a partner with Wilson Sonsini Goodrich and Rosati. And as I said, one of our legal experts, or our legal expert on Inside America's Boardroom. So welcome, Bill.
Thank you, TK. Always a pleasure to be with you.
So we're going to jump around here. We're going to take some shots at certain things that are issues, but we're going to start with board minutes. So we did a show on board minutes just recently, but the question that we didn't get to answer then that has since come up is taking notes at board meetings, okay? Should directors take notes, yay or nay?
So my general view is that directors should rely on the minutes that are taken by the corporate secretary of the board to be the record that reflects what occurred at their meetings, whether it's in committee meetings or board meetings. If a director is an excellent note taker, takes extremely good notes, I don't have a problem with the director doing that. My concern is that not every director is an excellent note taker, and that those notes might wind up in discovery, in litigation. They may contain observations or comments that are unflattering or that are critical or could be construed as being critical of the board or the process or the decision that the board was making and be exploited unfairly in that way. So that's my concern, and my recommendation to directors is make sure you've got a really good set of minutes being created by your corporate secretary that reflect what the board was doing, that reflects the questions that were being asked, that reflects the advice you were receiving from whatever sources. And that record will be useful to you later because it'll help remind you of what happened at the meeting, which you might be asked about in a deposition 2 or 3 years later. So I would rather have a good set of corporate minutes be the resource rather than the director's notes.
So be careful on the notes for discoverability.
Correct.
Okay. Next question. So we received the question of whether when somebody is an expert on the board, not necessarily fully designated that way, but let's say that somebody is a financial expert, may even be the financial expert for the audit committee, or somebody has a history of being an M&A expert in their career, or somebody is an IT expert. Does their liability, if there are problems in any of those areas, does their liability increase because of their expertise?
No, and it shouldn't. Directors who have particular skills or expertise should not be held to a higher standard of liability. That said, it is unfortunately the case, though, that if they have specialized knowledge and they don't use that specialized knowledge in a way that would benefit the board and the company by, for example, if they are a financial expert and they have reason to know that advice that the board is receiving from a financial advisor that's been retained or from management is incorrect, and they don't speak up and use that expertise that they have to point out the error or the flaw, then that's a breach of their duty of conduct, their duty that they owe to their fellow board members to bring their expertise, whatever it is, to bear. So there is potential liability under the right circumstances if they don't use their expertise in the way that a director should to fulfill their duties of care and loyalty. But just in itself, standing alone, expertise doesn't lead to some higher standard of review or liability.
I'm sure there's going to be a lot of people who have asked that question and are going to feel good about that answer. So let me move on to something that is so prevalent today, and that's cybersecurity risk, okay? And the board's liability for cyber risk. And we've seen most recently Equifax, but before that Target, LinkedIn, I mean, any number of companies that have either been hacked by people as a sort of a sport to see whether they could go in, hacked by people that want to sell that credit card information on the deep dark web, or what's really scary is state-sponsored sort of espionage and hacking, which whether it could be by China or Russia or somebody that wants intellectual property or something that will that they can steal from the U.S. So you almost can't prevent. I don't think there's any board that can prevent getting hacked. The question is, what's the director's liability? How is that mitigated? And what's the process for mitigating it?
Well, it's a good question, TK, and it's one that many directors ask me, and when I give them the advice I give them, it's couched in this way. Directors have duties of care and loyalty. That's their basic fiduciary duties, and out of those duties comes the duty of oversight or monitoring the corporation. So, for example, they have to oversee the company's compliance with legal requirements. And in the cyber area, they have the same kind of oversight responsibility. And there was a famous case in Delaware, a landmark decision really called Caremark, where this duty was explained. The board's obligation is to establish a system that will monitor whether it's legal compliance or whether it's monitor potential data security risks, and that the board then, after it establishes that system to do that, that it actually has a way of following and making sure if any red flags pop up that show some risk, that they are responding to it. That's a very high standard to show that a director has breached that duty, and it's a very difficult standard, probably one of the most difficult under corporate law today to meet, for a plaintiff shareholder to meet. And so as long as there's a system that's been established by the board, and so long as they're monitoring it and paying attention to the reports that come up through the committee that the board has assigned this duty to, and then to the board, and they act on whatever recommendations management or the experts that they've hired, they may need outside experts to advise them on this, and I recommend that many times. That's the test. Have they created a system to monitor the compliance and the oversight of the security risks? And are they addressing any deficiencies or weaknesses in that and responding to them in a timely way?
Now, you say that the bar is high, okay? But it seems very basic if a court case comes up and the board was not involved, meaning there's nothing in the minutes to reflect that they had discussions on this. There's nothing to reflect that there's been processes oversight by the board. That doesn't seem very high, if
well, you're right.
If they're void of that.
Right. If you don't have a process that's reflected in a record in a way that a judge or a reviewing body can see, then you've got real problems. I often use this old metaphysical story of if a tree falls in the forest and there's no one there to hear it, does it make a noise? The corporate law analog to that is if a board of directors follows an exemplary process but has no record of it, will a judge still respect what the directors did? And so you don't want to find out the answer to that. You want to be sure that you've got a record that reflects what you've done in the way of designing that process. So your minutes, your reports, and so on document what you did. That's the key ingredient.
Well, and we've already seen samples where that's important. Target was a good example of that, because that was one of the bigger shots across the bow, the earlier breaches. And the good news for Target was when they went back, they saw a process, they saw things. Were there things that they could have done better? Yes. But who knew that somebody was going to come in through an air conditioner vendor to hack their program? But in this case, to your point, there was a process. The process proved that there was oversight on the director's part. So it set the bar very high for somebody to say that they weren't doing their job, correct?
That's correct. Now, of course, there are all the costs that go with cyber breaches, that even though the liability bar is very high, and if directors design a good process and follow it and document it, the liability bar is such that they shouldn't be terribly worried. But they should be concerned about all of the other costs to the company,
Ramifications.
the costs of dealing with the cyber breach and the reputational effect
Right.
and so on.
Well, there are so many other risks that we could talk about, Bill. We don't have a chance. I will say that you and I just had an opportunity to address a group that we were told is filmed, and if so, we're going to make that available as well, where we did have the chance to get into more depth in some of these situations. So we'll try and make that available. But I wanted to thank you again for taking the time to join us here. And again, we had the pleasure of being here at the Hilton and Sally Institute for Corporate Governance and Integrity at Lipscomb University, and we want to thank them for offering these studios for us to have this
I
show.
join you in that. It's been a great visit, and I've enjoyed being here, and I always love to be in Nashville.
Yeah. So that will conclude this edition of Inside America's Boardrooms. We hope you enjoyed the show. We'll be back again next week when we take another look at a critical topic that'll help you be a better board member or committee member. So we'll see you then.
Join us again next week for Inside America's Boardrooms. Brought to you with knowledge partners NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini Goodrich and Rosati, Donnelly Financial Solutions, and the Society for Corporate Governance.